All right, good evening, everyone. So we are recording the session and we are live on YouTube. So we have everyone. We have Madam here, Ashish here. Right, let me start. So welcome you all to this wonderful session on shared planning awareness. This is the first in series because the last year we have been doing the program on the parental alienation, and by this time we have seen multiple PALs going around. The from starting from PL or from Mumbai, from Child Race Foundation, then evolved into the Calcutta 2025, then to Delhi, sorry, then to Karnataka, then Delhi. Recently, in many places that we are attending, and recently in Chennai also people have gone forward. So we believe this is the right time where we start focusing on the jurisprudence. We made awareness of the medical issue, that is parental alienation. Now we have been we have got people whom are affected. Super Daddy is here, Mrs. Ian is there. We have invited people working on the issue like uh, uh, Dr. Rakesh Kapoor, Rajit Mitra, and Miss Deepika, advocates from Mumbai, child psychiatrists, child psychologists, psychiatrists, specifically endocrinologists, pediatricians. We had varied people. And what we understood is that now slowly we want to go into a attention of the law legislature because we need to make sure people who are going to come from now are going to understand this problem, how to present it to the judge over there, and how to make the clients understand this. So then we associated with we had a very significant association with the School of Law from Dhanlakshmi University, and we are very pleased to have Dr. Ajay Madam here with us. She's a dean. She's very supportive. Thank you, ma'am, for joining, ma'am. We are in the process of having an international conference also, which we're talking, and we want to get everything in motion. And Ashish, member of the Parent Alienation Support Group from Michigan, I'll be introducing Mr. Ashish, but this is a very brief thing about for everyone to know about how this program has evolved. So when we spoke, we understood that this is the need of the hour. So we're writing a book on the cost control. And now he's in India with us currently. We've been discussing for the past 2, 3 months of how to get the program right because his time zone and our time zone are not being matching. He's a very busy man. He gave only 1 day per week, and the two of the time wasn't very matching for us. And luckily he is here in India, and I thought okay, this is the right time to have him on the show. So first, I'll invite Dr. Rajeshri Madam to this program, ma'am. Ma'am, welcome, ma'am. You are known to many people here, and you are. Hi, ma'am. Asked. I think you can unmute yourself. I have not placed any restriction. You can unmute. Yeah.
Yes.
Thank you, ma'am. So let me introduce you. She is Dr. Rajeshri Madam, very known figure in case of academic circle, in case of legal. I mean, law colleges. She has done an LLM, MBA, and PhD. She's very supportive for this shared parenting. Right now, she is having a post of dean from School of Law from Dhanlakshmi University, from my own hometown, from Trishnapalli. And madam, please introduce the speaker. Please take the program from here, ma'am. Thank you so much.
Good evening, everyone. Today, we are having a shared parenting awareness program. I'm very happy to be here, part of the here. I must say thank you to Natesh Prabhu sir, first of all. On behalf of the School of Law, I'm welcome you to all. Today, actually, we have a wonderful topic that is that the main theme, child's right to access both parents. Actually, first of all, I wanted to invite respected Mr. Ashish S. Joshi sir, distinguished collaborators and faculty colleagues, students, legal professionals, and most importantly, parents joining us this evening. A very warm welcome to you all. So today is a Parents' Day because, and what better occasion than this for Dhanalakshmi Srinivasan University School of Law to host a meaningful conversation on the theme. Actually, shared parenting focusing on the child right to access both the parents. I extend my heartful gratitude to our collaborating organizations also, that is Children After Divorce and Samhita and Ayushman and Bamboo Tree for parenting with us in this important initiative. I also thank each one of you for joining on this evening at 7:30 p.m. also to join here, and as you are having any busy schedule also, to discuss an issue that directly impacts the most vulnerable members of the our society, because our children is the backbone of the country, so that we are very much interested to take care of them. Why are we here? Why we are here means the problem we don't talk about enough, because we frequently discuss child nutrition and child education, but we rarely speak about a child's emotional security after a family breaks down. Am I right or not? Kindly accept. We have to accept the truth. So when a marriage ends, we are talking about the property, we are talking about the bank accounts, and we are talking about a household belongings are divided. But actually, unfortunately, the child is often divided too. It is very painful to speak actually. The child becomes a weekend visitor to one parent. Actually, we are unable to speak that weekend visitor, but that is a practical one. Or worse, the child becomes a messenger or a spy or even a weapon in the conflict. The law calls it is a custody. We are called as a custody, but actually, unfortunately, we are speaking about this today. Because which parent do I lose today? That is why today's discussion is so important. So, Article 21 of the Constitution guarantees every individual the right to life for a child, life without meaningful access to both parent and often in incomplete life. But what is shared parenting? Many of them, even my children, my students, if I'm telling this word, actually, what Sar is telling that we are planning to conduct the international conference. Actually, I am requesting in this platform, we need your help also. Because in this also, our students are asking, what is shared parenting, madam? We don't know this word, so we don't want this topic like that. Actually, Natesh Prabhu are also there. Then we given the clarity, what is there. So what is the shared parenting and what is it not? So shared parenting does not mean a strict, actually 50-50 division of days. See, but by speaking itself, we are having a painful. It does not require divorced parents to become close friends again. So shared parent meanings both parents remain equally responsible, equality involved, equality available in the child life, emotionally, financially, and in making important decisions. Let me share three practical examples. Actually, many we are having that, but because of the time schedule, we have to speak at least. I wanted to share some three examples, because sometimes if I say one, I read it in one article also. Then only I taken this example, the school admission form. Actually, this is a very pain. A mother writes father name no, so NA. So a father writes a mother name NA. The child sees the form and incorrectly asks, actually innocently asks, am I only half mine? Half mine? Because see, mother is unable to write a father name. Father is unable to mother name, because child doesn't know why they are not writing their name. Shared parenting reminds us that both parents' names belong on the form. Both parents should attend parent teacher meetings, because the child deserved both the parents. So, for example, one more example is masters, a medical emergency at 2 a.m. For example, a child develops a high fever. The mother calls the father. He replies, "It's your week." See how they are sharing to the week also. It is your way. It is your way. The child may never forget the response. The message received is, my pain is inconvenient to you. See, shared parenting teaches us medical emergencies do not follow custody calendars. So, for example, another example, as I want to say, and I will conclude, the silent birthday. A father is denied access to his child for 6 months because of court delays. He sends gifts. He sends birthday wishes. He yes, the child is told he doesn't care about you. Years later, the child grows up believing a lie. Because this is known as parental alienation, friends. So it is emotional abuse, really. Although unacceptable in principle, it often continues as a practice. What do the law and the world say that? Indian courts have consistently held that the welfare of the child is paramount. The Honorable Supreme Court, we know that in decisions such as Geeta Hariharan versus Reserve Bank of India and Roxman Sharma versus Arun Sharma has emphasized the importance of the both parents remaining involved in the child's upbringing. So, however, the welfare of a child cannot be measured only through school fees because they are sharing, school fees, maintenance, or financial support. True welfare also includes who comforts the child at a bedtime, who attends a sports day, who explains menstruation to a daughter, who explains menstruation to a daughter, who teaches a son to shave, who celebrates birthdays, festivals, and milestones together. Around the world, family justice system are evolving. Parenting coordinator, they appoint parenting coordinators, child psychologists, family counselors, but here and impose the consequences where a parent deliberately obstructs the child's relationship with the other parent. It is therefore our privilege to have Mr. Ashish S. Joshi ji, a distinguished family law attorney from the United States, joining us today. Through his extensive litigation and experience and scholarly work, he will share valuable insights into how American and Canadian family courts safeguard a child's right to meaningful relationships with both the parents. India has much to learn, including strengthening meditation and mediation before litigation, and encouraging structured parenting plans, and using technology for virtual visualization, training judges and lawyers to identify parental alienation at an early stage. So, the role of law, society, and each one of us as a law school, our responsibility is threefold. First, to educate, second, to advocate, third, to sensitize the society. That is very, very important. So, a message to every parent joining us today. I understand that separation is painful. Anger is real. Disappointment is also a real. Betrayal is real. But your child did not break the marriage. Your child is not a referee. The greatest gift you can give your child is to say, I may not like your other parent, but I will never stop you from loving them. Friend, as a closing remarks on this Parents' Day, let us make a collective pledge today. Let us move from saying my child to our child. Let us ensure that no child is focused to choose between Appa and Amma. Let us ensure that no child celebrates Diwali with one parent and Pongal with guilt. So, as Dhanalakshmi Srinivasan University School of Law, under the visionary leadership of our Honorable Chancellor Ayya, Sri A. Srinivasan, remains committed to legal education that serves society with compassion, justice, and humanity. So the programs such as today's are meaningful steps toward that commitment. I once again extend my sincere gratitude to Mr. Assis S. Joshi for joining us from the United States, our esteemed partner organizations, and my faculty colleagues, our students, and each one of you for your gracious presence. It is now my privilege to invite Mr. Ashish S. Joshi to deliver his keynote address on parental alienation and child's best interests. Lessons for Indian Judiciary from American and Canadian Family Courts. We look forward to learning from your valuable experience and insights, sir. Thank you, Jai Hind. Thank you so much, sir.
And thank you so much for the wonderful introduction, because you almost covered the whole thing in a very just talk, man. Thank you so much. So let me take the privilege of introducing Ashish formally. I'm going to put you in a spotlight. So Ashish is from US, but basically he's from India, from part of Gujarat, right?
Yes.
So he is the owner and the managing partner of Joshi Attorneys and Counselor, where he serves as the lead counsel in high stakes complex family law cases in the US and internationally. He has represented clients in the state and federal courts across the country and in multiple jurisdictions abroad. His practice focuses on complex family law and the related disputes, particularly cases involving intimate partner violence, parental alienation, child psychological maltreatment, and international child abduction. Mr. Joshi is also an author and speaker on high conflict dynamics and trial strategy. He has published extensively and presented for the American Bar Association, the National Association of Criminal Defense Lawyers, that is NACDL, and various state and local bar associations. He has held leadership roles within the ABA section of the litigation, including serving as editor-in-chief of litigation, and has served on the board of directors of NACDL. He is admitted to practice before the Supreme Court of the United States and is licensed in New York, Michigan, the District of Columbia, and Gujarat, India. It's a privilege and honor to have a distinguished speaker with us who is going to share valuable insights about how we're going to learn from an already evolved legal structure in US and Canada. Welcome, Joshi. It's all yours. Thank you so much.
Thank you, Dr. Prabhu. It's a pleasure to be here. And thank you, Dr. Rajeshwari, for the wonderful speech and the introduction. I could not agree with you more in what you said about putting the children first. That's what all is this about. I'm going to share a PowerPoint presentation, which I'll be happy to share with all of you, and Dr. Prabhu can then distribute it to all of you. It has some of the case law from Canada, from the US, and Indian courts as well about parental alienation for sure, but also the behaviors that the courts have found to be very concerning. So before we dive into the substantive topic, a little bit about my journey. I grew up in India. I went to law school in Gujarat. I practiced law in the High Court of Gujarat before going to the US. I got my second master's from University of Michigan Law School, and I'm barred mainly in New York, Michigan, and DC, and the Supreme Court of the United States as well. My practice focuses on trying cases involving family violence. So it's mainly litigation oriented, but I also do a significant amount of teaching where I teach at judicial conferences in the US and abroad. And I teach the lawyers in how to handle a case involving family violence. It could mean that you might have a client who's a victim of domestic violence. It may also mean that you are representing a child who is caught in a family violence circle. It may mean that you're defending a parent who is falsely accused of domestic violence. And in the recent years, I've been doing a lot of publication and teaching about representing men who are victims of domestic violence and emotional abuse. Because not enough is said and written about male victims of abuse, and our fathers are being emotionally abused, financially abused, not just by the partner, but also inadvertently by the legal system that they are caught in. And more judges are being now very familiar with this kind of abuse, which we shall cover down the road. So if I may, let me share my screen with you so I can share the PowerPoint. We are going to talk about how parental alienation intersects with the child's best interests and the lessons that we can learn from North American and Canadian family courts. And it's not because somehow these courts are better than our Indian courts. It's only because there's a significant wealth of material that comes from the UK, from Canada, from Australia, from the US, which these decisions have incorporated in their judicial opinions. And this is where some of the Indian family judges can learn how to differentiate a case involving emotional abuse from that involving physical abuse. What is and what is not parental alienation? Why is alienation so harmful? And most importantly, what do you do? What do you do as a judge when you find evidence of alienation? Because early intervention is a key in these cases. The more time that goes by without a parent seeing a child in a meaningful capacity, the harm is at times irreversible. There are several cases from India where the fathers have been relegated to basically a visitor, an uncle, or a cousin in the child's life. There are cases where they call these parents Santa parents or Santa dads. And by the same token, there are cases where the similar things have happened in other jurisdictions to mothers as well. So it's not about dad versus mom or mom versus dad. As the dean said, both parents are important in the child's life. And in the US, at least, there's a strong statutory presumption that the child needs to have both parents in his or her life. Some of my publications here, I'm the author of books involving family violence. Litigating Parental Alienation is one of my books that came out in 2021. And this year I came out with another book, Litigating Family Violence, which is an overview of alienation, yes, but it also covers emotional abuse, child abduction, child interference with the child's custody and parenting time, international abduction of children, also litigation and legal abuse, how sometimes a parent, a father, or a mother is caught in the legal system and has to spend enormous amounts of financial resources, emotional resources just to get to see your child, just to get a meaningful visitation. And what can the courts do about it, and how can we do a better job of helping these people? So let's talk a little bit about how the US courts understand alienation and why it matters to them. Whenever there's a case of a divorce or a separation, and a judge has to make a decision about visitation or parenting time or custody, they rely on what is known in the US as the best interest factors. And these best interest factors are statutory factors that every state has its own statutory template, so to speak. It's quite similar. There's almost a deep level of uniformity around it, but still best interest factors in California, for example, would differ from best interest factors in New York. But this is what a judge looks at when they have to evaluate a case. In some jurisdictions in the US, now we have laws about shared parenting, where law presumes 50-50 custody. And in order for one parent to get more custody and more parenting time, he or she has to demonstrate to the court why the court should do that in the best interest of the child. So in other words, the burden is on you, the parent, to demonstrate why the court should not order 50-50. And that's a huge leap, because otherwise there's no such presumption in place. And there has been some research, preliminary research, that needs to be looked at closely, but still it shows that in cases and in jurisdictions where the shared parenting laws have been put into place, there has been a dramatic decrease in conflict and dramatic decrease in litigation, which is great news for the courts because it does away with the backlog. So these are the factors that American courts look at when deciding child custody and parenting time issues. They look at parent-child relationship from a historical perspective. How involved has the father been in the child's life? How involved has the mother been in the child's life? What are the mental and physical health issues of the parents? Does the child have any special needs? For example, is the child autistic? Does the child have severe ADHD? Are there any other issues that the child has that puts the child into a category of a special needs child? And if so, which parent has more sensitivity towards that? Which parent has more awareness about the child's needs and to meet those needs? Who is able to provide stable home environment? Are there any issues of alcoholic or substance abuse? Are there any issues or patterns of domestic violence in the family? So it's a template of various factors. There is no particular weight attributed to one factor versus the other. And it's totally up to a judge's discretion in how a judge weighs these factors. So, for example, you could have a case where a father, let's say, may have had some alcoholic abuse in the past or may have some alcoholism issues. But nevertheless, the court could give the father 50-50 custody or sometimes more because the father is able to demonstrate that those issues are not current. He has gone to the rehab, he has done the treatment, he's willing to be a good parent, he's willing to parent in a safe and stable manner. So the court can take various things into consideration when deciding how to apply this best interest factors. One case that I pointed out in this slide is from the state of Michigan, where I'm from, Makarevik's case, where the judge decided that the factor A, which talks about the love, affection, and emotion existing between the parties and the child, and in that case, the child expressed very strong affection for the mother and appeared to be very closely bonded to the mother. But the court found that that bond, in fact, was unhealthy. It was unhealthy because the mother had influenced the child to reject the father. The mother had engaged in brainwashing behaviors. The mother was enmeshed with the child. So, what appeared to the court from a superficial level to be a close and bonded relationship, the court decided to look further and decided that no, the father needs to be a part of the child's life here. And it's not enough just because the child says that he or she doesn't want to visit the father to cut the father out of the child's life. So that's a great example of how a court evaluates different factors depending on the evidence that's presented before the court. So the best interest factors mainly rely to the custody of the child, which means that decision-making powers, which are typically medical, religion, educational, mental health. But then together with that, the court also decides parenting time. So for example, the court could award 50-50 custody to father and the mother, but the court could award significantly more parenting time to the mother or vice versa, depending on the historical role in the family or the availability of a parent's time for the parenting tasks. And similar to the best interest factors, the court looks at parenting time factors when deciding this. And these are the parenting time factors, statutory factors that the court looks at when awarding parenting time. And typically they are whether a parent has historically exercised parenting time, or has the parent been mainly an absentee parent? Has the parent reasonably exercised parenting time as per the court orders? Is the parent capable of complying with the court orders? There are cases where a parent has repeatedly violated the court orders and refused to turn the child over to the other parent. There are cases where the parent has repeatedly interfered with the other parent's parenting time. For example, the child goes to see the father during the weekend visitation, and the mother keeps on calling the police to do a wellness check. The mother keeps on calling the child during the father's time, or the vice versa situation. And if the behaviors persist, the court can look upon this as gatekeeping. or interfering behaviors which are not in the child's best interest, because they undermine the child's relationship and enjoyment of the relationship with the other parent. So let's take a look at some of the judicial decisions of alienating behaviors that Canadian and the US courts have found to be very troublesome, because these are adverse to the child's best interests. The alienating behaviors are considered as child psychological abuse or child emotional abuse. Sometimes the court used the word child psychological maltreatment. And there's significant amount of research behind this classification. So let's take a look at, for example, the decision from Ontario, Canada, where the court decided in a case involving alienation allegations and found that alienation is a legal concept in family law as opposed to a mental health diagnosis. And a family judge, a court can make a finding of the presence of alienation dynamics or parental alienation based on the analysis of facts without expert evidence. And this is an important decision because many times an argument is made by a parent who is facing allegations of alienation that a judge cannot make the determination without the expert testimony of a psychiatrist or a psychologist or a social worker. And in many cases, parents simply don't have the resources. In many situations in the US and Canada and elsewhere, the judges have a father and the mother who are representing themselves because they may not have funds for hiring even professional attorneys to represent them. And in that situation, the parties don't have the funds to hire a top-ranked psychologist or a psychiatrist to come and testify in the court. So is the court's hands tied in that situation? Is the court supposed to be blind towards alienating behaviors which are fact-specific? And the judges disagreed that no, we don't need an expert to come and tell us that if a parent behaves in a particular way, that behavior could be harmful to a child. Judges can definitely evaluate human behavior. They can judge a human behavior or a pattern of behavior and decide whether that behavior is harmful to the child or not. So this was an important decision which laid down the sort of a precedent that family courts do not have to rely on experts alone to make determination of alienation. This is another decision from the US, state of Michigan, Martin versus Martin, where the court found alienating behaviors. And the parent, instead of trying to counter the allegations of fact, argued that parental alienation syndrome is basically junk science, or parental alienation syndrome doesn't exist in the psychiatric literature, such as the Diagnostic and Statistical Manual, DSM-5, and therefore the court should ignore and dismiss all allegations of alienation. And the court disagreed. And the court said, while there may be some controversy regarding the syndrome or regarding parental alienation syndrome, there is no reasonable debate or there is no controversy surrounding the behaviors or the acts themselves. So if a court has evidence that parent A, whether a father or a mother, could be either one, has repeatedly interfered with the child's relationship with the other parent, has repeatedly engaged in gatekeeping behaviors, has repeatedly violated the court orders, has repeatedly encouraged the child to reject, disrespect, demean the other parent, then these behaviors are enough for the court to determine whether alienation exists or not. This is another decision from state of New York, where the court has said the same thing, that actions matter and actions speak louder than the words. One more decision from Arkansas as well, where the American courts have found a similar kind of behavior where a parent hid the medical information refused to share that with the other parent, did not allow the other parent to access school information, did not let the child have calls with the other parent, visit the other parent. And that's where the court stepped in and found this behavior to be very harmful to the child and the child's relationship. Okay. I'm unable to advance my PowerPoint. I don't know why. Oh, there we go.
Got it?
Yes, thank you. One another decision from state of Connecticut in the US as well, where the court found that it was not in the child's best interest to comply with the child's wishes. And this is an important concept. The best interest factors that we saw earlier has a factor called the child's preference. And this becomes a key battle in cases involving alienation in litigation, because the court is required to obtain a child's preference. Now, imagine we have a case of severe parental alienation. And let's say that parent A has alienated the child against parent B. When the judge interviews the child in a confidential setting in camera, as they do typically, the child could say, I don't want anything to do with parent B. I don't want to see the parent B. I don't want any visitation. I want parent A to get full custody because parent B doesn't love me. I hate parent B. He or she is mean. He or she is abusive, etc., etc., etc. Is the court simply required to accede to those wishes and the preferences without doing any further analysis? No. And that's what happens in cases involving alienation. The court has to look whether the child's voice is genuine, whether a child's feelings about the other parent, which are so negative, are feelings based on the child's own experience or influence. Has the child been subjected to alienating behaviors? And in this case, the court found that it was not in the child's best interest to grant the child's wishes or preferences because the feelings that the child had about the other parent was because of brainwashing. The child was simply poisoned, as the court put it, against the other parent. And one parent had sowed the seeds of hatred in the child's head about the other parent. Similarly, a case from Pennsylvania, which we saw a case from Ontario, Canada. This is an example from the US as well, where the court found that we don't need an expert to tell us whether a parent had engaged in bad behavior. We can make those judicial findings as family judges on our own. And we do those things. We do make those findings. Similarly, another case from New York. Here, it's a case from India, originating from state of Kerala, where the court found that the mother in this case had engaged in alienating behavior to the extent that it amounted to mental cruelty to the father and undermining the relationship between the father and the child. And the court found clear evidence of alienating behaviors present in the case and how mother engaged in those behaviors. Similar to Kerala, this is a case from Delhi as well, where the court found similar behaviors by a parent engaged in alienating behaviors. And I would like to clarify one point. I mean, if you look at these cases, you might find that courts have found mothers to have engaged in alienation maybe more than the fathers. But that's not the case. When we look at the case from a broad overview and do an analysis of cases from all different jurisdictions, it almost appears to be 50-50 situation. And the case law and the social science research shows that both genders have engaged in alienating behaviors. And we'll see a case as we go on where the court found that this is not about mom versus dad. It's about human behavior. Yes, there's peer-reviewed research in how women engage in alienation versus how men engage in alienation. And that's a very sophisticated piece of research that shows light into behavior and how alienation affects a child's head, whether it's in by mom or by dad. But just because I picked some cases involving fathers being the victims of alienation doesn't mean that moms and mothers are not victims. They too are victims in cases where fathers have engaged in alienation. And in some cases, especially in cases where there is a strong cultural aspect of joint family system, where the extended family members live together or are in close proximity to each other, you also find third-party alienators or proxy alienators, as courts call them. For example, the court might find that it's not the mother who is the chief or the primary alienator, but the grandpa and the grandma, the grandmother, the grandfather, the uncle, the aunts. Together, all of them have carried on a campaign of denigration against the father. And the child has been exposed to this campaign of denigration. And while the mother has not been the primary instigator or the primary alienator, she has been passive participant or a passive observant, and she has failed to protect her child from this negative influence of her family. And the court found that to be alienating aspect by proxy or third party alienation. In fact, it's interesting, in some situations, I've come across appellate cases where the appellate courts have expressed a very strong objection to the trial court's behavior and the trial court allowing a case of alienation to languish without appropriate intervention and not intervening early enough. And the appellate courts have found that this case, unfortunately, is a judicially sanctioned alienation or judicially created parental alienation, where the alienation was entrenched and made stronger because of the court's refusal to do something about it. So let's talk about why alienation is so bad and why the courts take notice of that. And it's about a child's exposure to the parental conflict. In any divorce and any separation, there is some amount of conflict. But we have to distinguish healthy conflict from toxic conflict. In a healthy conflict, in that situation, there is some movement, there is curiosity. Questions are asked. The people may not like the answers, but there is a movement towards trying to find some resolution. People are looking for a resolution. They're trying to agree on some parenting time, some custody, and there is give and take. In toxic conflict, there is no such curiosity. It's driven purely by animosity and purely by emotion. And high conflict and hate is part of it. It's a system. There's no movement to get to a resolution. Conflict is the destination because there's nowhere else to go. And that's what happens in many, many, many cases which are caught in the legal system because of the backlog of the courts or because the court's refusal or failure to intervene early and provide the safeguards that are needed to protect the child's relationship. This is a great book about high conflict, how people get trapped and how to get out of it. And it provides some real good solutions to the conflict as well. One thing that has created more toxicity in conflict is the presence of social media and how in the recent years, social media has created this far worse where there are echo chambers being built and litigants who are caught in litigation try to join some groups. Some groups are helpful on social media, some are not. But when a party litigant, let's say a dad or mom, joins these groups and they constantly hear about the family court corruption, they constantly hear about attorneys, judges, and all negative aspect of it, it's sometimes easy to caught in the toxicity and lose the focus of your own case. And that could lead to filing of court papers, pleadings, making allegations, which are not really helpful in getting to a resolution. And the judges have taken a note about some of the social media groups and how they affect litigation in more toxic manner. For example, you often see labels being used in court such as a narcissist or histrionic, abusive person, alienator, gaslighting. And these are clinical concepts. So, for example, to call a father a narcissist, I mean, that sets a case in a particular trajectory, and it gets a response from the parent who is accused of being a narcissist falsely, and it creates a lot more toxicity and conflict to begin with. So that's where the courts have been really cautious and have really cautioned attorneys who are officers of the court to not use these terms, clinical terms, without appropriate investigation and without cause. So fathers' rights groups versus mothers' rights groups, they both have their value, they both have the support. But at times there are some groups which cause some more problems. For example, in Canada and the US, it's really troublesome and at times violates the court orders and statutes to share confidential court documents on public sphere in social media. And you often see parents putting on court decisions or a guardian ad litem report or something on the social media to look at, which reveals the identity of minor children, which discloses sensitive information. And in that situation, the courts have stepped in very quickly and reprimanded the attorneys, have put in financial sanctions, sometimes to the tune of thousands of dollars, and have immediately removed those materials from the hands of the litigant and the attorneys. So you have to be careful in how you share documents with larger groups, depending on the jurisdiction. This is a good decision from a New York court where the argument was made against parental alienation, saying that parental alienation is a hoax and it's just used by abusive men to counter their abusive behavior, to hide behind their behavior, and so on. And the court strongly disagreed. The court said this is not a gender war over the children. And we reject any such simplistic analysis. Alienation is real. It is the behaviors are manifested by men and women, and we are going to look at the behaviors. We are not going to get into the gender war over this. Some important decisions, social media as well. So let's try to segue into a somewhat different topic. And this is something that has been coming up very much in courts in the past 5 years, and we are seeing more and more of this. Allegations of coercive control. And coercive controlling behaviors are behaviors which constitute domestic violence. They are seen as a part and parcel of the domestic violence umbrella by the family courts. And it's a behavior that's a combination of abuse, intimidation, isolation. It has been engaged in at times by men, at times by women. Children have been exposed to it. Children have been used as pawns or as tools for coercive control. And the courts are very sensitive toward this kind of behavior and what it does to the child. The courts typically look at the power and the control wheel when domestic violence comes up. And one of the thing when you look at the power and the control wheel is using children as power and control. And often the use of children ties in with the alienating behavior as well, where a child is used as a weapon by one parent against the other parent, where the one parent uses the court systems to abuse the other parent and take the child away without any justification, where the details are inappropriately shared with the child of litigation and underlying the court process. So coercive control is an important exposure that needs to be focused on. Similarly, the child's exposure to patterns of abusive parental behavior is what the court looked at when deciding alienation. And this can constitute financial abuse, where one party has significant or exclusive control over the family's finances, where one parent is completely cut out, is not allowed any access. There's lack of financial transparency. There's significant amount of isolation involved as well, and force involved. It could be an emotional and psychological abuse, where one parent is conveying to the other parent or to the child that he or she is worthless, where the child repeatedly sees a parent being humiliated, being denigrated. Some time ago, I wrote an article which you can find on my website, and you can download all articles for free without any cost. And it's about the fathers who are victims of emotional and psychological abuse, and where a child repeatedly sees the father being denigrated, being humiliated, being shamed by the mother or the mother's side of the family, and what that does to the child's psyche and well-being, and how that's part of the emotional and psychological abuse umbrella as well. Physical abuse, of course, is domestic violence, and the courts quickly step in. Where there's physical abuse, the police and law enforcement are involved quickly as well. But unfortunately, law enforcement is not involved as much and as fast as it should when it comes to emotional, psychological abuse. And that's where we are seeing more and more training of the child protective services workers, the social workers, police officers in recognizing signs of emotional abuse when they're called to investigate cases of domestic violence. The sexual abuse involved of intra-party by one parent against the other, but sometimes unfortunately involving children as well. And litigation abuse. This is where I earlier talked about legal abuse, where one party keeps on filing unnecessary, frivolous documents, court pleadings, motion papers, where there are hearings after hearings in the court which don't go anywhere. And precious time is lost where the child is growing up without having a father or a mother in his or her life in a meaningful way. And legal abuse is something that the courts are taking note of, where one party has been seen or found to have engaged in frivolous, or what the courts call vexatious litigation. In some jurisdictions, such as California, for example, there are laws against vexatious litigation. And if a party has been found to have engaged in vexatious litigation, the court allows the other party to get fully reimbursed for attorney fees and costs by the vexatious litigant. And then the courts put in some kind of safeguards. For example, a vexatious litigant is not allowed to file any more motions or court pleadings or paperwork without getting an approval from a magistrate or a referee judge. There's some sort of a gatekeeping put in place to stop the other party from being abused by the vexatious litigant. And the court looks at the pattern of behaviors when considering what's vexatious and why it's vexatious. Delay and stonewalling are main parts of it also, but also filing unnecessary motions, repeatedly seeking adjournments without good cause. This is especially important in a jurisdiction like ours in India, where there is so much backlog of cases, and the cases are pending for years and years and years at time, sometimes because the adjournments are granted without sufficient cause. And that's something that the courts are taking note of as well. Trauma is another thing that comes up in family courts, and courts look at it as well. Understanding trauma explains the court as to the effect on the child when one parent is cut away from the child's life, when the child suddenly can't see a parent in a meaningful way, and the child doesn't know what happened. Sometimes the child is told some falsehoods. You can't see your dad because your dad's unsafe, or your dad doesn't love you. You can't see your mom because your mom walked out of the marriage, your mom cheated on your dad, or things like that, which is not what a child should be told. Children are not supposed to be burdened with adult issues, and that could result into long-lasting consequences. But trauma is something that lawyers need to focus on as well, because you could have a client or a parent who has undergone trauma but has not been diagnosed with trauma. So in those situations, you see some behaviors which could appear to be bizarre to a layman from a superficial perspective. You could see, for example, parents being so stressed they behave erratically. They laugh out when they are nervous. They ask the same questions again and again without being able to process the information. When they are testifying in court, they are unable to provide the information that the judge needs in a real cogent and helpful manner. So as an attorney, you have to understand that you might have someone who could possibly have PTSD or could have suffered a trauma. And in those situations, it's important for the parent to work with a parenting coach and the attorney to be patient in getting the information out from the parent and presenting it in a helpful manner before the family court so that the court understands what's needed in the situation. There are trauma reducing strategies as well that the courts can look at and the lawyers can look at. Effective listening is, of course, one of them, but also to build a case to get the facts out that are required before the court. For example, if the court has been told falsely or inaccurately that the parent is not safe or dangerous, then it's absolutely critical for you to build a case showing the videos or photographs of the prior positive relationship that the parent enjoyed with the child before being cut off from the child. The judge needs to see those evidence pieces. The judge needs to see what the relationship looked like before the separation so that there could be a proper juxtaposition of the current allegations versus historic relationship that the parent had with the kid. What helps in this situation, in alienation situations generally, early prevention is a key, early intervention is the key, early management of these cases is the key. In some cases, the court orders family assessment, which means that a professional could be a psychologist, could be a social worker, could be a mental health counselor. They assess the family dynamics. They interview the father, interview the mother, interview the children if they are age appropriate. They may provide some psychological testing. They may interview collateral witnesses, such as a school teacher, a neighbor, extended family members, and they prepare what is called a forensic report, a child custody evaluation report, or a comprehensive psychological evaluation report of the family dynamics, and then present it to the lawyers and the judges as to who should be given custody and why, whether custody should be shared, whether one parent should get sole custody, whether one parent should get more custody, and why. So the lawyers have to work with this professional within the system. Not all courts do that. Some judges do this on their own because there might not be money available to hire these professionals, or there might not be the time at hand. So it depends on where jurisdiction are you. It's also helpful to have clear-cut court orders where the court's expectancy from a parent is clearly delineated and the parent knows what's expected. And even more important than that is enforcement of a court order. A court order that is not enforced is not worth the paper it's written on. And that's what family courts who handle these cases in an effective manner do it from the day one. So for example, if there is court ordered parenting time that says 50-50 parenting time between the dad and the mom, father and the mother, and let's say the mother says that, well, the child could not go and see the father because the child refused to get into the car, or the child refused to go and see the father and I could not force my child to see the parent, the court, which is effective, will immediately take action. It will immediately hold a hearing. It will immediately ask the mother to explain why can't she make the child comply with the court orders. You can make the child go to school. You can make the child go to a medical appointment. You can take your child to a dentist. You can make your child go and see the other father, the other parent. So either you are an incompetent parent or there's something going on, but we are not going to tolerate this. So the courts that have ordered make-up parenting time and have sent a clear message that it's not going to tolerate violation of court orders are the courts that have managed these cases extremely well. By the same token, the courts that have allowed repeated violation of court orders have created a nightmare where the court orders no longer have any efficacy. The court orders no longer apply. And you have a situation where the child now gets into the driving seat of the conflict, and the burden is put on the child whether to see a parent or whether to comply with the court orders. And those cases turn very, very toxic quickly. Presenting evidence in the court. It's important, as the court decisions tell us, that allegations are just that, allegations. There are numerous cases where the courts have rejected claims of alienation or claims of parental alienation because there was no evidence presented. So it's important to distinguish allegation from evidence. And in the court of law, you have to present evidence, not just allegation. And you have to do it in a way that evidence court works. In certain situations, it may be critical to present the court with expert evidence, not in every case, because expert evidence takes time, effort, and money. And sometimes, as an attorney, you have to make a decision as to whether your client is better off by going to court now and presenting facts as evidence instead of spending time, effort, and money in trying to find a psychologist or a psychiatrist to explain to the court the concept of alienation. Avoid labels. This is something that the courts have repeatedly told us, that don't be bothered with the diagnosis and the clinical labels, present the facts. Facts are what matters. Let's talk about some of the common misconceptions or misunderstandings about parental alienation that are commonly put forward before the courts. So there's the myth about emotional abuse that if a parent has been found, for example, to carry on a campaign of denigration, a campaign of bad mouthing against the other parent, it's just words. Words don't hurt like physical abuse. And the research tells us the opposite, that emotional abuse and psychological abuse is as harmful as physical abuse, and sometimes more. A child who is exposed to brainwashing behavior, a child who is exposed to parental alienating behaviors, a child who repeatedly sees one parent being denigrated, disrespected, has long-lasting adverse consequences. And the courts have taken this notice of this science again and again about the neurobiological consequences of alienating behaviors. The other myth is abusive parents do not love their children. And the courts have found that love and abuse can coexist. A parent can genuinely love the child, but still behave in a manner that causes the child to be alienated from the other parent. And that parent lacks tools, skills, and support. And that's where early psychoeducation can be helpful. But if despite that early psychoeducation, a parent refuses to change the behavior or refuses to modify his or her behavior, then the court looks at the next step, which is to minimize the contact between that parent who is engaged in abusive behavior and the child. We talked about this myth that parental alienation is a hoax and it's only used by abusive men who hide behind these claims of alienation to protect their behavior. And again, the research demonstrates that alienating parents are far likely to be more abusive than the targeted parents and make false allegations of abuse as well. Men can be victims of domestic violence or coercive control. False. The research shows that intimate partner violence is not a gendered phenomenon. Both men and women are victims of violence, and intimate partner violence is reciprocal and bidirectional, not unidirectional. These are some of the references I have for you at the very end of peer-reviewed social science literature and case law as well. They are available on Google Scholar. You can get them, most of them. If for some reason you can't find these cases, please feel free to send me an email. I'll be happy to share them with you if I have them available at my hand. There's a lot of resources in terms of articles on my website. You look at the publication resources and you can download all the articles that you believe are helpful to you or your attorney in arguing the case of alienation. And again, it's what a pleasure and privilege to be here with you. I think we can open the question and answer round if there's one. I'll be happy to answer any questions if we have. Thank you.
Thank you, Ashish. Excellent session, well balanced. And I have a few questions. Let us Let me start with number one, and let us ask the people to unmute and ask this. So, what is actually happening? Because we understood that even though it is, we think the judiciary is more progressive, still issues have been facing over there, right? You, you stated that people have 50-50 custody as a default, and people fight for additional parenting time. Am I correct?
It depends on the jurisdiction.
Okay.
There's a common presumption across all jurisdictions that a child needs both parents in the life of the child.
Okay.
But that doesn't mean that it's 50-50 custody. You could still have a meaningful role in the child's life by having, let's say, 40% custody or 30% parenting time. It depends on the situation. So, for example, if historically, let's say the father has been serving in the military, and because of the service in the military, the father has been posted abroad on military missions or military bases and is not actively involved in the child's life who is back in the US. The court will take that into consideration. And in that situation, even though legal custody may be shared 50-50, physical custody may be shared more in terms of 70-30 or 80-20, depending on the situation. We have to differentiate legal custody from the physical custody, and these two are separate concepts. I think you're muted.
You have been practicing here and practicing there. What is one strong difference between the judiciary over there and here the practice and the attitude? How do you see that? Starting from the family court to the higher courts and to the Supreme Court.
Well, one difference that I have seen when working with the American and Canadian courts and in European jurisdictions as well is the availability of the judicial resources. It's far easier to get before a judge and have a hearing in a meaningful way. The backlog that Indian courts have is simply beyond anything that I have seen. And it's not because our judges are lack empathy or they are callous or they are lazy or anything of that nature. It's simply the ratio of judicial officers versus the number of cases pending in a court is dramatically different when you compare India to, let's say, New Zealand or Canada or US. So I think we need to be cognizant of that situation and increase the number of judges or somehow have reasonably amount of dockets available so these cases can be adjudicated in an expeditious manner. The other difference I've seen, which makes a lot of difference actually in practice, is I've not seen adjournments and continuances granted as easily as they are granted in Indian courts. So, for example, if you have a date of hearing and you want to get a continuance or an adjournment, you have to show a really good reason. It's not simple. It's not just enough to say that the attorney is not available or the attorney has some conflict or some other matter going on in a different court. As if you are an attorney, it's your job to be prepared and to ready to go when you have a date in the court. So that's something that really makes a difference in the long run.
Understood. So we have a few audience questions. I'm going to unmute Prashant here. Prashant, you can ask.
Yeah. Thank you very much, sir. My question is about the assessments that are needed for either the child for the or the parents. So what I've seen recently was one system described by Dr. Childress. So he mentioned that three things has to be checked. That is the family system, the parents' pathology, and child's attachment system. So uh, is it done on a regular basis or not? And if parents do not consent, then what is the way around? So what I believe from his talk was that the system that is playing for custody evaluations and all that, even that can be gamed. So some of the parents, the insecure parent is willing to do and play tricks to try to game that system as well. So it's kind of a cat and mouse game that is going on. So even if the systems improve, uh, the insecure parents might find a way to trick it or get a benefit out of it. So that will keep on happening. So I wanted to get your views on it. What would be better?
That's an interesting question. And as I'm thinking it through, uh, it depends on the jurisdiction. It depends on the case at the end of the day. Not every jurisdiction is so eager and so quick to order a family systems assessment or a child custody evaluation. Now, if a parent has some sort of an undiagnosed personality disorder, then that parent is going to behave in a very erratic manner. He or she will try, as you say, to game the system. But that is precisely what these evaluations are supposed to capture. Those kind of erratic behaviors and those kind of distortions in thinking patterns. And if it works, then the court makes the decisions keeping those findings in mind. If a parent refuses to comply with what's ordered, and if they keep on making false allegations, for example, we have seen many cases where a parent believes that the other parent is dangerous, is unsafe, is abusive, despite all the evidence to the contrary. And in that situation, the parent repeatedly goes to the police, repeatedly calls the protective services workers, repeatedly goes to the school, keeps on accusing the other parent. And after the evaluation, if the court finds the other parent is safe and these concerns that the parent number one has are unfounded, are delusional, then the court will change custody and reduce the other first parent's time with the child in a significant manner. The court at the end of the day can't change someone's thinking or someone's beliefs or someone's mindset. What the court can do is to contain the behaviors and how those behaviors affect the children by reducing the access that that parent has with the child.
Thank you. So I'm going to unmute Srinath here. Hi, Srinath, you can unmute yourself. Unmute it. Please ask question.
Okay, thank you, sir. Thank you everyone for the valuable inputs. The most of the discussions are pertaining to a child age less than 18 years. But in my case, my concern is that my daughter is as of now 22 and a half years, but her mental age is of 10 years. So courts are not considering the mental age; they are only considering the physical age. This is the first point. Second is that. I wanted to know more about the guardianship and the custody. Whether one parent can get the guardianship and the other parent can get the custody, and simultaneously shared parenting also. I wanted to know whether any such situations are there in your this in Canada also. So two questions.
Sure. So let's talk about the first one. If a child is above 18, in most jurisdictions, about, I would say 99% of them, the child is considered to be emancipated, which means that the child is no longer a child, but the child is now an adult, and the family courts have no jurisdiction over that adult. So the courts can't do anything about it. If it's a situation where the child's competency, the cognitive or behavioral or emotional capacity is severely compromised and the child cannot function as an adult, then a parent or a caregiver or a guardian has to petition the court for guardianship. And the court then conducts a hearing. The young adult now could resist it, and the court may or may not award guardianship. Guardianship is different from custody. It's similar in some aspects, but different. And every jurisdiction matters. What a court may do in New York, for example, is very different from a court in California, in Canada. So you have to look at your jurisdiction. In some situations, when the child gets to be an adult and is out of the court system, and there's not been an opportunity to intervene to remedy alienation, that's really a tough case, because then you no longer have the court's arm or the court's intervention to help you. And then you may have to rely on some good therapists or consultants coaches who can help you how to reach out to your alienated child in a manner that the child could be willing to listen to you. But guardianship is a very arcane and jurisdiction specific issue that you'll have to look at in which jurisdiction you are in.
Okay, thank you. So we are moving to the next question. Mr. Vivek Shahu, please ask question.
Thank you, Tony, Mr. Joshi. And thank you, Dr. Nitesh. My question was like, I mean, is there any kind of, legal advisory exchange between the countries where the sensitive matters like, child parental alienation, things in the child custody case? I mean, the kind of suggestion can be taken from the countries which are, have done the good work in this area, like US or Canada, as you have explained in your slides. The courts, the judges are themselves are capable enough to analyze that whether the parental alienation exists. So I mean, if that kind of things are there, where the legal advisory can be exchanged between the country, and if you can work on that towards that, and uh, the the judges in the India can be educated on that area, like they will be able to recognize the pattern of the parental alienation, because here it's very difficult for judges to, I mean, they are not educate enough to understand these things, and most of the judges are even don't know what is a parental alienation basically. Like like we have the UN uh, convention for the child custody, where they mention like the child should not be separated from their parents, and it is just keep them safe and abuse. And if it is abusive parent, then it's the case. Otherwise, their share parenting is the norm from the UN, but that is not enforced actually. So any kind of channel is there between the international, uh, legal advisory.
Well, I'm not sure what you mean by legal advisory as such, because the cases from the US and Canada or elsewhere, they don't have precedential value in Indian courts. So Indian judges are not bound by them, so to speak. But if you read the decision from our Supreme Court in India, we often find that the justices refer to the law reports in the UK or the US Supreme Court decisions as well. So they are persuasive value. They are not binding value. Same goes for American courts, where they may not have Canadian decisions as a binding precedent, but they are looked upon as learned treatise or something holding persuasive value. In terms of exchange of information, there are obviously always international conferences where judges go to interact with each other. They learn about family law, they learn about the latest research in the family law setting. But it depends upon the resources that each bar association or the country has, whether they're able to send their judges to such conferences or not. I mean, I visited, for example, several years ago, I was a part of delegation from the US where we visited the Indian Supreme Court, interacted with the justices. We went to Delhi High Court, interacted with the Delhi High Court judges. We went to Bombay High Court, interacted with Bombay High Court judges, and we talked about various concepts of family law in North America and how we could have meaningful exchange with Indian judges as well. So these kind of efforts are always put into place. Um, in terms of Indian judges not understanding parental alienation, not being aware of it, I've seen sometimes the same being true in some areas in the US or Canada, let's say a rural area, or really a judge who may not have background in the family law before getting on the bench. So it's the job of the lawyer representing you, or if you are self-represented, if you are the litigant, to try to help the court understand this. And you can do it by showing the judicial case law from your jurisdiction, or your state or a neighbor state or a sister state, Supreme Court decisions from India as well. If you go to my website, for example, if you go to the resources under publications, you will find 2 articles where I have discussed Indian cases on parental alienation, including Indian Supreme Court's cases as well. So that will give you an idea about how Indian judges do understand parental alienation. And if you happen to be before a judge who doesn't understand it or doesn't really know what it means or why it's so harmful, you could present these resources before the court in a way that that's acceptable to the courts as well. But if I'm throwing this out for everyone here, if you find, I mean, there's an opportunity or your bar association is holding a presentation on alienation where judges are invited, I'd be more than happy to participate and share my experiences and research on that issue.
See, what you said is correct because we are at judgments from Madras High Court also. The judge, they describe the contents over there. But the final judgment will be a different thing. They write the whole thing. This is what is so. I can quote one order from 2011 from Madras High Court. I'm not sure that the right name, whether he is Ram Subramanian. This is from a case of Vanitha Vijayakumar, where he has told something about there is no, we should not use the term visitation. Term visitation should be condemned. It is about a different kind of word he used. And one more thing what he mentioned was the child's intelligent preference or influent preference in the judge's chamber. So these are all good terms which you can. He quoted the international conference on shared parenting also. So these judges they quote, but once a quote, it could be, as he told, this could be a persuasive value, and not a binding value. That's one thing. And my question is, you kept saying the judiciary in US are sensitive to the issue. What does it mean? A sensitive means what do you mean by sensitive? Means they respond and they pass order. What do you mean by sensitive? Number one. And second,
I didn't hear that. Could you repeat that, please?
You mentioned the judiciary are sensitive to these issues. So they understand and they react in a better way or just keep quiet. That is one thing. And second, what about the false cases over there? Here they here so the apparently alienation is not only the weapon. IPV it has all the amount of false cases, DVC. So what's the mentality over there? And third is I'll come to that, the child mentality. How is children over there in US or reacting to alienation and what they talk inside the court?
Okay, so let me take them one by one. So what I mean by courts being sensitive to alienation allegations or family violence dynamics is that when these allegations are made in a court of law, the courts take immediate or prompt notice of that. They are quick to hold hearings. They are sensitive towards these dynamics about how they need to be dealt with quickly. There are proper procedures put into place, proper professionals appointed in the case. For example, an appointment of a guardian ad litem who is going to interview the child, who is going to obtain the child's preferences, interview the parents, and provide a quick report to the court as to what's being done in the situation. In terms of false allegations, it happens everywhere. There are several cases, hundreds of cases in the US and Canada, where one parent is accused falsely of abuse or some other things. At the end of the day, like any other allegation, the court has to look at the evidence behind it. And there are cases where there's a pattern of false allegations being made against a parent, and court has found that pattern to be an abusive behavior in itself. Because every time there's a false allegation, the system kicks into the gear. The police show up at the doorstep. The protective services workers interview the child. If there's an allegation of sexual abuse, the child is made to undergo sexual assault nurse examination, which is very intrusive. And the courts have held that this kind of pattern of false allegations robs the child of the childhood. And it's an abuse in and of itself. And the courts have acted on it. In some situations, the parent making false allegations have been prosecuted because it's a felony in the US to make a false police report. So depending on the severity of the case, the court takes action. But generally speaking, the courts I have seen, they always err on the side of caution. Just because the prior three allegations have resulted into unsubstantiated CPS reports doesn't mean that the fourth allegation will not be investigated. It will be investigated. So there is time, effort, and money put into it. But if there's a pattern of such false behaviors, and the courts look at it as to what's causing that. And the last one about how the children react to alienation, I'm not sure I understand. Are you talking about the social science about the adverse effect on the children for alienating behaviors?
No, I'm telling about how they react in the court.
Oh, so a child does not come into the court directly. What happens is that the child is either interviewed by a guardian ad litem or by a judge in camera, which means that neither parent is present. And the judge asks, for example, if the child is known to avoid father, and the child is not seeing the father, a judge would ask the child about, tell me about your dad. What do you think of your dad? What do you think of your mom? How much time would you like to spend with your dad? How much time would you like to spend with your mom? Why? Tell me five good things about your father. Tell me something that you think were your fondest memories with your dad. And if the child has no fond memories, nothing good to say about the father, if the child says everything all bad about the father, all positive about the mother, well, that's a red flag for the judge. So the judge asks some more questions and they go into it. So those preferences are elicited from the child, and then the judge decides whether those preferences are reasonable, whether they are genuine, or whether they are under influence, and they can decide that. In rare cases, I've seen older teenagers around the age of 14, 15, or 16 testify in the court where there are allegations of abuse being made, where a child unfortunately has been exposed to a conflict, or there was a domestic violence incident and the child was a witness to such incident. In those case situations, the court might have a hearing which is close to the general public, and the child is allowed to testify under some protective measures. But those are very rare cases.
So it's a good thing because so they don't call the children to the open court, or it's a
No,
good thing.
no. In
Absolutely.
fact, in fact, in alienation cases, what at times happens is that the alienated child starts writing letters to the court. And the judges not only reject these letters and refuse to read them, they in fact make a record of it, that the chambers received a letter from the minor child and the court has not read the letter. It's highly inappropriate. So it will alert the favored parent or the alienating parent that this behavior is not going to be tolerated, and the child needs to be given a clear message that this is not going to happen. If the child needs to convey something to the court, it has to be done through proper channels, such as talking to a guardian ad litem.
It's a good thing. And before going to Zian, we have a special guest to our show. Zian, just a minute. We have Deepika here. Deepika, can you? Yes, let me unmute for you. Ashish, you must have been knowing about Deepika, right? Deepika
I think
Narayan, she's a men's right activist, I mean, equal
yes.
activist,
I
I'd
mean,
say.
I'm known offer and I've heard about her.
Yeah,
Unfortunately, we've
she has
not met in
made a lot of
person.
documentaries, and it's a pleasure to have. And we all welcome you, Ms. Deepika.
Thank you
She
so
has
much,
special.
Dr. Nagesh. Thank you so much. I wish I knew about the program earlier. It would have been a pleasure to actually join it, but I just came back from a event where I was speaking. And thank you so much for giving me this opportunity to address the audience. And I was listening to Ashish, and it was very interesting. I wish I had attended the entire session, but just to share very briefly with all everyone here, I'm a I've been working on issue of parental alienation, not with full force, but with all my heart in whatever way I can for the last couple of years. To 2026 has been special because Ekam Nyaya Foundation, my NGO, along with AIFCR, we filed a PIL in the Delhi High Court, and it was accepted. And the Registrar General has been asked to formulate shared parenting guidelines in Delhi. We intend to move the Punjab and Haryana High Court next. And I have done a lot of interviews with fathers who have suffered because of this. And last but not the least, a very recent case that has come from Allahabad High Court, where interim custody of a minor daughter has been given to the father, with the court observing that the child was being tutored to file a false case of sexual abuse against the father. This father has been in touch with our NGO for quite some time, and when his wife was trying to lodge a false case of sexual abuse against this person, we spoke to the higher most police authorities, and we ensured that the FIR of POXO is not registered against him. So we try and help as many fathers as we can. Day before yesterday, we were working with the father till 2 a.m. in the morning because the child was taken away by the police suddenly. So trying to do whatever we can and whatever difference we can make in this space. Thanks, Natesh, for all that you do.
Thanks so much, Deepika, for joining this session with us. So I think we can move to the next questions here. So you can ask.
Yeah, hi. Ashish, I think we've been closely talking about in terms of a need for more of these seminars and educating people from the judicial fraternity. So it is great to, in fact, have this session over here. Again, my two bits in terms of the takeaway is that unlike in the US and in Canada, out here we have seen instances wherein children have actually been called to the family court in terms of testifying that which would be the preferred parent that they would like to be with. And since the alienation has already kicked in whatever phase it could be a mild or a moderate, because the refusal is already present, in terms of not being with the non-custodial parent. The biggest challenge out here is, one is obviously getting the orders of sufficient parenting time. Even if non-custodial parents do go ahead and get that after whatever time period, it could be a bare minimum to around a year. The parental alienation syndrome already kind of kicks in, and then even if non-custodial parents do get some orders, the custodial parent again tries these tactics to ensure that the parenting time is not being observed, and there is a gross violation of the orders as well. So we've been trying very hard, with a lot of awareness on platforms, uh, through Dr. Natesh, through Bamboo Tree Children's Foundation, through seminars hosted by Ekam Nyay Foundation, to kind of get people in the judiciary as well to be sensitized on that front. But there's a lot of work to be done, especially when it comes to the awareness in terms of shared parenting.
Indeed, I mean, it's really heartbreaking to learn that the children are allowed to testify in open court about the preferences. I mean, that's something that I've seen the American and North American and European courts to be very sensitive about it. I mean, their preference, their voice is obviously always heard in the court, but not directly. It comes through a professional or it comes to the court in a sensitive and confidential manner. But to put a child in a witness seat and being and allowed to openly express a preference of one parent against the other in an open courtroom could just entrench the alienation in the worst possible way. And what the research tells us is when a child is made to reject a parent because of alienation, the child internalizes that guilt. Because in the heart, the child knows that my mom, for example, who I'm rejecting, or my dad, who I'm rejecting, he or she loves me. He or she is a good parent. And the guilt that's associated with that rejection is internalized. And you see that come out in self-harmful behaviors, suicidal ideation, eating disorders, violence in school, sexual promiscuity, drug abuse, and all of that. And we have had research after research after research. And that's why, at least in the Western part, the judges are getting more and more sensitive towards early intervention about it.
Thank you so much. So today's session was very enlightening. We had a great discussion, and we wish we'll be having more sessions with Ashish on different topics, because once you go through his all articles, you have plethora of knowledge in case of child custody litigations. And we wish we're going to have you soon for an international conference which we are planning along with School of Law, DSU. Ma'am, you were a lot of thanks and remarks, ma'am. Rajeshwari madam.
Thank you. As we conclude today's session, I sincerely thank Mr. Ashish S. Joshi for his valuable and inspiring presentation. Really very good. And whoever coming here and distinguished guests and faculty members or students, especially for Natesh sir and all. Today we learned about the parental alienation, the importance of the best interests of the child, how American courts decide child custody and parenting time, and how courts addressing alienating and behaviors. We also understood that the best solution is for parents to find common ground and always put the child's welfare first. The most important message from today's session is that every child deserves the love, care, and the guidance of the both parents whenever it is the child's best interest. So on behalf of the School of Law, Dhanalakshmi Srinivasan University, I extend our heartfelt thanks to Mr. Ashish for sharing his knowledge and experience with us. I also thank all of our faculty members and students and participants for making this program a success. And more time, actually, many of the are very much interested to ask the questions, and a very insightful program today. Thank you, Natesh sir, and thank you, Ashish sir, one more time. Thank you, and have a wonderful day. Thank you. Thank you so much.
Thank you. It's a pleasure to
Thank
be
you, everyone. Thank you. Thank you, Ashish. Thank you, everyone. Thank you. Thank you, ma'am.
Thank you,
So
sir. Thank you so much.
we'll meet for the program soon.
Thank you very much, Natesh sir.